Court of Appeal, Division 1 is now in session.
Good morning, please be seated. This is the time and date set for oral argument in CV21-0233, Barton Cheryl Shea versus Maricopa County. These proceedings are being video and audio recorded as well as live streamed, so I ask you introduce yourself and who you represent at the beginning of your presentation. Each side will have 20 minutes to present their argument. Appellant's counsel is responsible for reserving any portion of that time for rebuttal argument. Also, we've read the briefs, we've conferenced this case, we're familiar with the facts. Please take that into consideration during your presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
Good morning. My name is David Lunn. I represent Barton Cheryl Shea. I'm with DKL Law Firm. Bart Shea is with us today. If I may please the court, I know you've read the briefs and conferenced the case, but I want to give you just kind of a brief background why we're here. So the county filed a complaint against the Sheas saying that they had violated the zoning ordinances because they didn't have final building permits. Well, the Sheas purchased their property in 2000 and then pulled building permits, which was undisputed, and constructed their main house and a guest house for their Mrs. Shea's mother and the father-in-law. They lived there for 17 years when there was a complaint filed with the county saying that they were doing construction without a permit. And Mr. Shea he's a general contractor, and he was performing some termite repair on the side of the house. And because of the size of the construction, there wasn't required a permit for that. So when the investigator for the county looked into this issue to see if there's any permits, they searched the database and couldn't find a permit. It's important to note there's two databases. There's a permit plus database, which is historical permits up to 2008, and the Excella database, which is 2008 forward. Excuse me. The Sheas built their house in 2003, so the permits in that base would have been in the permit plus base. And the testimony was that the county in 2006 destroyed all the information in the permit plus base. So when the investigator went to go look and determine whether or not there's permits, he went back into the other database and couldn't find a final permit. And thus that was the basis for the claims against the Sheas. Mr. and Mrs. Shea went to the hearing. Mr. Shea represented themselves.
Counsel, I understand and I appreciate the factual recitation. It strikes me that there's a fairly significant jurisdictional issue here that I would very much like to hear from you about.
Yes. So the jurisdictional issue is based upon when we went to the Board of Adjustments, we appealed there, and then timely within 35 days we filed a complaint to the Maricopa County Superior Court. Mistakenly, it was filed as a special action. So we went to this, so the county filed a motion to dismiss, and the trial judge, Judge Cohen at the time, determined there's various case law from the Supreme Court that, and along with the language of ARS 12902B, that what the Supreme Court's cases say from Shepard and on is that it doesn't, as long as the court has jurisdiction over the claim, it doesn't matter the technical designation of how it was here. So you could cite a statute for the jurisdiction, but if the court actually has subject matter jurisdiction, it has jurisdiction over that case. And in this case...
Counsel, here it seems like you were doing more than just seeking review of the board's decision. The complaint seems to also talk about retaliation. I assume, was that part of the case before the board? Or if you're just seeking review, were you just seeking review, or were you trying to do something more than seeking review of the decision, the board's decision?
It was, well, the board's decision was a vote. They didn't really do any analysis into the facts. There was no written opinion saying, here's what happened. So we have to go back and look at what happened at the where the hearing was held. And the hearing, pursuant to their own statute, the Maricopa County zoning ordinances, you're not allowed to have discovery, you're not allowed to do anything else before the hearing. So you just show up. So when we were contesting what happened, we're contesting on various grounds. One was due process, there was declaratory relief, and part of it was, we believe, retaliation because...
But did you argue retaliation at any point in the administrative proceeding?
In the administrative proceeding, no.
Well, so that's not an appeal of the administrative decision. To the extent you're arguing, I'm looking at paragraph 48 of the complaint, seek a declaration the department and county's actions were the result of improper retaliation. Is that something that came up at all during the administrative proceeding?
I don't believe it did per se. I think that when Mr. Shea was testifying at the hearing, he implied that. So I don't think it was that part really wasn't the core of the case.
But would you then agree that your special action verified complaint is not necessarily limited to being an appeal of what the board did? It's going beyond that, and you want to have presumably a hearing on whether there was a retaliatory motive? Is that?
No, that really wasn't what the crux of our complaint was. The crux of our complaint was that there was due process violations, that they weren't able to present evidence that they've since discovered during the case in chief. So that was really the crux of our case. And you can, once you file the administrative review claim, you can have it de novo, and Judge Cohen, sua sponte, gave us de novo and let us engage in discovery, which we did. We took depositions, and that was all part of what we did during the case. And as I mentioned in our brief, there was, just by the timing, there were like 3 different judges involved in this thing, as it got transferred to different judges. And the next, after we were going with Judge Cohen and we started proceeding down that path, another judge was, and we prepared briefs, another judge then decided to look at the jurisdictional argument and decided that there wasn't subject matter jurisdiction. And that's what we're saying was wrong. There's clearly subject matter jurisdiction over this case because it's founded on statute. And there's no other place that Mr. and Mrs. Shea could have brought this claim besides the Maricopa County Superior Court. There's declaratory relief action. That goes before Maricopa County Court. Due process claims. That's where it belonged per statute. I know that there was the special action in the complaint that it's a different procedure, but it's not about the procedure. It's about, does the court have subject matter jurisdiction?
So the challenge is not under the Administrative Procedure Act, or it is? Which of those two?
The challenge should have been filed under the Administrative Procedure Act. It was mistakenly filed as a special action. So what was, motion was dismissed following saying the court does not have subject matter jurisdiction over this issue. And we're saying, yes, you do, because it's founded on statute.
Well, let me ask you a different hypo. What if the appropriate appeal from the APA decision was filed 40 days after final agency action, so it wasn't timely? Isn't that an issue of subject matter jurisdiction?
Not in this case, because we actually
I understand it's not in this case. That's a hypothetical.
Yeah. And so this is the bulk of the cases relied on by the county are that exact situation, where they didn't file any complaint within 35 days, or there was cases where they had to file within 14 days, and they filed 18 days later.
And isn't that subject matter jurisdiction? I want to make sure I understand how you're using the phrase, and I'm not sure.
That is, I mean, well, that would be a timeliness issue, for sure.
Okay.
If there's, it'd be...
You agree that the court lacks jurisdiction if you file an untimely request for review, whether you call it a special action or a...
Yeah, if we didn't file a complaint within the 35-day period...
But isn't there a requirement that it be filed in timely and in the correct manner? Isn't there also a manner requirement?
Well, that's the interesting thing about it, Sean. And there was... When we looked at the different case law that we cited in our briefs, and particularly the language of ARS 12902B, and it's very broad. The legislator termed it to be very broad, how you're going to challenge this claim. It specifically says, in part, that it if under the terms of law governing procedure before an agency, administration decision becomes final because of the failure to find any document in the nature of an objection, protest, petition, or application for administrative review within the same time. And when you're looking at jurisdiction, presumption is there is jurisdiction. And unless there's some sort of specific statute that divests jurisdiction, jurisdiction exists. And here the legislature, certainly by enacting 12-902B, intended there be broad basis to seeking jurisdiction. So it didn't matter at all. And just like Judge Cohen stated that it's emphasizing there must be timely notice of a claim challenging the underlying action. And that's what was filed. It was filed within a 35-day period. So, and that's consistent with, various case law in the Supreme Court from, State versus Supreme Court, State versus Maldonado, Shepard versus the Parole Board. And it's really subject matters jurisdiction. If it's not late, I agree that would be time barred. But the question is, did we file an objection, an action, within 35 days that the court would have jurisdiction over?
So your perspective is the form of the filing doesn't matter. It's the timing.
According to the plain language of the statute, that's
Well,
correct.
I just want to understand your position because I think there's some rules in case law that may counter that. And so if instead of filing a complaint, you had gone to the clerk of the Superior Court and said, and filed a one-page document saying, request to challenge administrative agency, that would suffice.
According to the statute, any objection, any document is going to object or challenge it, yes.
Which statute in particular, what subsection are you talking about? Because B just says you have to, unless review is sought within the time and in the manner provided in this article.
Right.
Manner seems to be more to that than simply a piece of paper that says I don't like what happened.
Well, the manner provided in the article, you got to look at what it's requiring you to do, and you have to read further within the statute, which says, under the terms of law governing procedure, you must, it becomes final if you fail to file any document in the nature of an objection, protest, petition for hearing or application. So it is so broad saying that you can challenge this if you file any document within the prescribed period of time. You may file a document that doesn't have factual basis to challenge the claim, and that would be a different argument.
So if the only document that you file is the plaintiff is African American, and the only document that's filed is the board is prejudiced against African Americans, is that a challenge to the ruling, the underlying ruling that the plaintiff who's African American, is that a challenge to the ruling?
I guess you could say it would be a prejudicial challenge, but I think that would be something that you'd look at the merits of, and whether or not there's timeliness. Did they follow within the prescribed time, and was it a challenge? Was it an objection to what happened?
But could you file something that's unrelated? I guess everything in your view is related to the ruling by the administrative agency, and anything that you file that suggests that you're unhappy with that ruling, from your perspective, that suffices?
Well, not necessarily. I mean, you still have to meet the pleading requirements. You have to be able to say a concise fact about what the claim's about and everything else. There's still those requirements that you're...
So where in your pleading, sir, does it say we want to overturn the decision of the administrative agency? Where is that claim? We're appealing this decision. Yeah.
Under the declaratory relief action is what we were appealing.
And is that the manner that the Act contemplates? Is that how it says to raise that challenge?
It says you can raise a challenge by filing a document of the administrative challenging what happened. And so there was two different things that we challenged, or three different things. The due process aspect of it, the fact that all the evidence we discovered during the course of that trial was relevant to what happened there, and there wasn't an opportunity to do that in the underlying proceeding. So that's one issue. And because of the declaratory relief is that we're not liable for violation of these zoning ordinances, because in fact, the evidence shows we had these final permits, and any evidence we don't have one was destroyed by the county. So we were challenging the actual ruling by saying, yes, no, we shouldn't have been found liable for violating the county ordinances. That's correct.
Counsel, let me ask you, you focused on 902B and the requirements there, but doesn't 904A require a notice of appeal?
Well,
I mean, and that's in the context of the thought that my theoretical one-page filing with the Superior Court would suffice.
well, I don't know that it would, because you still have the pleading requirements that you have to comply with. There has to be ample information to give people on notice. And
Under the rules of civil procedure, right? But all that assumes jurisdiction, and what we're focusing on is whether jurisdiction of the Superior Court was properly invoked.
correct. And so the nature of the pleading that we filed was an appeal. We're objecting to what happened. We're appealing the decision. When we amended the complaint, there was no other allegations other than we were appealing what happened below because of various reasons we think it was improper. And that is exactly what we filed. We just labeled it wrong. But that doesn't, I don't know how that would divest the court over subject matter's jurisdiction over this issue. It was timely filed, and if you read, and like the case law says, you have to have, I can cite it for you real quick. I mean, in Dow versus Harris, 139 Arizona, 353, 1984, it says the presumption is in favor of jurisdiction rather than divesting jurisdiction. Divestment must be clear and unambiguous. Intended, and ARS 12902B intended to be broad as far as,
And
I think we're talking about.
Let me make sure we're talking about the same thing. The Superior Court has broad jurisdiction when properly invoked to review agency decisions. There's no question about that. The question to me here, though, is whether it was properly invoked. So I understand your focus on divesting, but the question to me is different. Was jurisdiction of the Superior Court invoked properly to begin with? And that's where we have the benefit of 2 or 3 Superior Court judges coming to different points of view as I see the record.
Yeah, and I understand that. What I'm looking at, and the different case law that we cited would say just that. If you cited the wrong statute, you cited, that doesn't matter. It's really whether or not this court has the power to hear what's, by statute or constitution, what's in your complaint. Do you have sufficient facts to do that? And the fact that 12902B states specifically you need to file an objection or document protesting this. So I think that the statute doesn't specifically divest jurisdiction, saying if you don't file this way, you don't have jurisdiction. It doesn't. And the case law, Dow says, well, it has to be unambiguous to divest jurisdiction, and it does not. In fact, it's the opposite, because 12902B does, in fact, say if you just file an objection, and that's really what was filed, and it was just a matter of changing the technical denomination of what it was. So I'll save my last 2 minutes for
Thank you, counsel.
Good morning, and may it please the court. My name is Joe Branco. Here on behalf of the county appellees, with me today is co-counsel Wayne Peck. I will address any issues related to Arizona's Administrative Review Act, and Mr. Peck has the good fortune of answering any questions with respect to the enforcement action or zoning law. Failing to follow the rules has consequences. In the action below, Shea attempted to seek review of a final administrative decision of the Maricopa County Board of Adjustment. Under Section 11-816B3, To obtain judicial review of the board's final administrative decision, Shea were required to follow the procedure in Arizona's Administrative Review Act. Shea didn't. Thus, under Section 12-902B, Shea were, quote, barred from obtaining judicial review of the decision, end quote. To be clear.
So, counsel, when we look at Boyston and it talks about defective notices of appeal not necessarily depriving the court of jurisdiction, we talk about sufficient notice and whether the notice provided, while insufficient, is misleading or prejudicial. So I'd like you to address the misleading portions of what was filed and how you were prejudiced.
And I'm sorry, which?
I don't know if they're aware of it. Boydston versus Stroll development, an Arizona Supreme Court from 1998, in which the Arizona Supreme Court said there was a defect in a notice of appeal. A party had filed, a non-lawyer had filed an appeal on behalf of a corporation. Everybody agreed it's a defect, you can't do that, you have to have a lawyer. And the Court of Appeals said it's a defective notice of appeal, there's no jurisdiction. The Arizona Supreme Court said, no, if the other side knew exactly what was happening, it's not a jurisdictional bar. If there's no confusion, and we're very interested in whether that underlying principle, if the county knew exactly what was happening, a defect, and we all agree there's a defect. Well, I guess they're arguing any document would encompass this, but I am reading their complaint, starting with paragraph 46. They seek a declaration that the department's finding and ruling was not supported by fact or law. It seems like they're challenging the board's ruling. So was the county confused that they were seeking review of the board's ruling?
And Your Honor, I don't know that I can answer that because it's not clear from the record. I think the confusion would stem from the fact that Mr. Shea admitted the zoning violation in front of the hearing officer, and really, how do you come back from that in an appeal? With respect to notice,
that's a different question than did the county know he was appealing that ruling? Is there any question about that? What else did they think he was doing at that point?
Your Honor, this is a little hard coming in cold from a case that wasn't briefed by any party. No, and I appreciate that. I think here's the easiest way to say it. And was that a case that went from the Superior Court to the Court of Appeals, or from the Court of Appeals to? Okay, so I think that procedurally, I don't, and I'm sorry this isn't answering the question. I have no idea. I'm appellate counsel. I don't know. I think that when you read the special action complaint, right? So coming in cold myself, the first thing I'm thinking is, I'm looking for special action jurisdiction, which is entirely discretionary. This is not even, it's cited, the special action complaint cited section 12-816D, which is, I believe, invokes the court's non-statutory.
Let me ask though, let's just say it's titled special action, but everything about it, the first paragraph is, there was a ruling on January 5th. We think that ruling was wrong. We want relief from that ruling. Would there be a question that they're seeking review of the administrative ruling? I understand this one's a little bit murkier.
Yeah, so let me stop fighting it. I don't think that there would be a question in that case. I think the problem we have here, though, is that if that principle is going to control, it's going to end up reading the term in the manner completely out of section 12-902B. Because that isn't, I want to be clear, we're not saying, oh, you flubbed the caption, therefore you don't get to go to the Superior Court. And there are a series of procedural things that needed to occur here, none of which did. And to refer to Judge Thomas' hypothetical about one page, could you have one page? You absolutely could. In 2018, the JRAD was revised to include Form 1, which is one page of what needs to be included, statutorily and in terms of the rules. So we've really got 4 statutes that weren't complied with. It isn't just the caption. So we've got the fact that it exclusively invoked that court's special action jurisdiction and tried to raise claims under the Declaratory Relief Act and 2 constitutional principles.
Well, let me ask then, if they're raising some claims that are outside review of the decision, why would everything be jurisdictionally barred?
In that case, those three claims wouldn't be jurisdictionally barred, consistent with the Administrative Review Act. They would, however, not be a proper special action because in Neary versus France, the court was very clear that if you want to sue about constitutional violations, Section 1983 is your adequate remedy.
But the ruling below here, it seems like the ruling is your complaint is jurisdictionally barred, which seems to go to everyone is of the impression that Mr. Shea is challenging the underlying ruling. This is an appeal from the underlying ruling, and it's jurisdictionally barred. If it's something more than that, then the ruling doesn't make sense to say everything's jurisdictionally barred.
I think it's two sides of the same coin. I think to the extent that it sought to invoke the court's jurisdiction to hear a review of an administrative decision, it fails because it didn't comply with and I'm happy to list them. I've even found more in preparing for oral argument.
That's where we get to. I understand that Boyd's done something that we just found in our own research, but it's a failure to comply with proper procedures. I mean, by having the wrong person file something, and the underlying principle is, were the parties confused?
Your Honor, respectfully, I want to push back on whether parties were confused because I think it's irrelevant. It's my understanding that the statute has to be strictly complied with. And so that is procedurally different than taking an appeal from Superior Court to the Court of Appeals. There isn't a statute that says the only way that you can sue the government to challenge an administrative decision, in this case, is by following in the manner. And so when you're taking an appeal from Superior Court to the Court of Appeals, this court all the time takes things that were improperly brought and doesn't waive them away on jurisdictional issues, but converts them into a special action because you have the power to do that under the rules. The statutes here very narrowly and carefully define what someone who wants to appeal an administrative decision to the Superior Court has to do, and that's by statute.
But what's your response to counsel's argument that B says it becomes final because of a failure to file any document in the nature of an objection, protest, petition for hearing, or application for administrative review? Does that just go to it doesn't become final yet, or it becomes final?
It's completely irrelevant. All right, so if under the terms of the law governing procedure before an agency, and we know from Southwest Paint that what we're talking about here is the internal procedures at the administrative agency, in the context of this case going from the hearing officer to the Board of Adjustment. An administrative decision becomes final because of failure to file any document, and that would be filed with the administrative agency in the nature of an objection, protest, petition for hearing or application, and this is the key phrase, I think, for administrative review. And it's making it clear that that is the failure to follow the procedure at the agency level. Within the time allowed by the law, the decision is not subject to judicial review. So that's if you make a mistake at the agency level, then you can only go seek judicial review on the issue of jurisdiction. And that's not what they raised here. So what we've got now is we've got two sides, I think, to the same coin. To the extent that they were seeking to challenge the administrative decision, it fails, and I'm happy to provide the litany of
But it failed because it was mislabeled.
It failed because it wasn't a notice of appeal. It didn't include identify the final administrative decision sought to be reviewed and include a statement of the issues presented for review. It wasn't a notice of appeal that contained a statement of the findings and decision.
But when you're saying it didn't contain, didn't they attach the administrative decision to the complaint?
They didn't.
That wasn't.
The only place that the board's decision is found is in Index of Record 22. In fact, I had trouble finding it, and I confess error. I inadvertently asked this court to take judicial notice of it because I didn't think it was there. And that's another thing that was done wrong. Section 12-904B says within 10 days after filing a notice of appeal, and for the purposes of this, Your Honor, let's assume we're just talking about a flubbed caption. Pursuant to the Act, the party seeking judicial review shall file a notice of the action with the agency that conducted the hearing. We don't have anything about that in the record. And I confirmed with Planning and Development before coming here today that there was nothing that they received until December 4th, 2018, 9 months after the special action complaint was filed. And that's in Index of Record 22. You'll see something, a letter from the Planning and Development to the Superior Court that attaches the letter from opposing counsel, and that's the first time that the notice of the action could have possibly been served.
Okay, but if they had, if the verified complaint had been labeled notice of appeal, would what you're discussing have divested the court of jurisdiction? If rather than filing a special action, a verified complaint for special action, if this had been titled notice of appeal, and it says the Sheas seek a declaration that the department's finding and ruling was not supported by fact or law, does the Superior Court have jurisdiction?
No, because the statutory scheme under the Arizona's Administrative Review Act was not followed. Even if the caption is changed. Again, the issue is not the caption. The issue is the substance of the filing. It was seeking things that either went far beyond an administrative review, appeal.
But why isn't that a different story, though? This is, my hypothetical is simply, it says notice of appeal, and or it says special action complaint, and let's go with notice of appeal, and the Sheas seek a declaration that the department's finding and ruling, and even take out the word declaration, the Sheas seek a ruling that the department's finding and ruling was not supported by fact or law. There's no jurisdiction to address the department's ruling under that hypo.
If everything else is the same in terms of the other procedures that were not followed, including the notice of the action, obtaining the record, then yes, that's correct. In the manner has to mean something. It can't just mean the caption. And it can't just be you slap together whatever your litany of complaints are and get it in front of the Superior Court. It has to mean something. This court has determined that the timeliness issue, which immediately precedes it, right, in the time and in the manner means something, and it means something jurisdictional.
Counsel, let me ask you, it seems to me, but I want to make sure I understand your position, that to invoke the, I'll call it appellate, but review jurisdiction of the Superior Court under the Administrative Procedure Act, three things need to happen, and I'll put them in an awkward order, okay? Something needs to be done in a timely fashion, needs to be filed in the right location, and needs to be in the right format. Would you agree with that? That's kind of where we need.
Yes, Your Honor.
And it strikes me that the first two, was a challenge timely? I think so. And was it filed in the right place with the court? I think so as well. But the dispute, as I hear it, is was this in the right form and fashion, right format? Is that a fair summary of your position?
Yes.
Okay. And I understand your perspective on that the format was not as required by the statute. And I'm using format in a generic sense. If there was no jurisdiction under the APA by the Superior, or the Superior Court's jurisdiction wasn't properly invoked, you had begun to mention Neri versus France and how the substantive claims might not survive. But I don't think that was a part of the Superior Court's decision-making here. Is that, or have I overlooked that? In other words, okay, fine, we don't have APA jurisdiction, but considering this as a special action, the due process claims, those either succeed or fail, and by definition, given that we have a judgment, the definition would have been fail. I don't see the Superior... Did the Superior Court's
decision did not address whether or not it survived as a special action. Of course, I don't think it needed to, and this court can affirm for any reason available from the record. And I think that this court is capable of looking at the special action and seeing that seeking things like declaratory, and I apologize, I don't have the case. There's a case that says, it might have been Sears versus Hull, that says you can't seek a declaratory action in a special action, right? Special action under these circumstances is limited to the questions in Rule 3 and is traditionally mandamus, prohibition, and certiorari.
And I get that I'm getting the cart in front of the horse, right? But if that's the case, and I think I heard you say earlier that special action is discretionary, that this is not a statutory special action in front of the Superior Court from your perspective, wouldn't the court at least have some wiggle room on whether to decide to exercise jurisdiction if this was in fact a non-statutory special action, something that we haven't seen that court address?
I don't think the court would have discretion. And the reason is because if it's a non-statutory special action under Rule 1A of the Rules of Special Procedure, it has to be something that isn't susceptible to an adequate, plain, and speedy remedy at law. And so the constitutional violations, as Neary versus France says, can be handled by 1983, so special action jurisdiction wasn't appropriate in that case and wouldn't be appropriate here. In terms of the declaratory relief, again, I believe the case is Sears versus Hall, and I apologize that I don't have it, says you can't seek declaratory relief, right? You've got to seek these other things. If you look as well at Arizonans for Second Chances, which admittedly was decided in 2020, it talked about, and so it would have been after this special action was filed, it talks about the need for a clear jurisdictional statement that invokes the court's special action jurisdiction. That didn't occur here either. So what we really have is we have a Frankenstein document that doesn't really accomplish either an administrative appeal or a special action. And so I think that this court can comfortably decide on the record that it doesn't need to go back down to the Superior Court to sort of perfunctorily say, well, I can't actually hear this as a special action. I think this court can affirm for any basis clear from the record, and that would be very clear.
I apologize if I'm just rehashing, but if the only defect, we're calling it a special action, and in all other respects, it looked like a notice of appeal, in your view, there's no jurisdiction?
Oh, no, sorry. No, if it's simply a misnomer, I think that's, I don't think that I don't think that that's the requirement. I think the problem is here is that, respectfully, the hypothetical starts straying so far from the document that was filed that it...
But isn't that the point, and I, again, understanding that Boydston wasn't on your radar, but if the point is, has anybody been misled? Does anybody misunderstand what's happening? I'm not hearing you say the county wasn't aware that the Sheas were seeking review of the underlying ruling.
I think it's best at this point to turn it over to Mr. Peck, who handled this in the trial court and was available at the administrative proceedings, and who's been tugging on my jacket for about a minute now.
Thank you, Your Honors. May it please the Court, Wayne J. Peck, Deputy County Attorney. To answer a much, much earlier question, Mr. Shea, at the administrative hearing, which is part of the record, did allege that the complaint was filed in retaliation, and our argument was we don't care because the statute is a strict liability. Either you have the permit or you don't. As far as the confusion, yes, we were aware they were appealing, but we had no idea what they were appealing. The hearing officer made 4 separate findings on, I believe, 6 structures that did not have proper permitting. There's nothing in any of the documents that told us what they were arguing about other than the house, so which had already been decided. So yes, we had absolute confusion. In fact,
that confusion seems different than whether there's jurisdiction. That means you're challenging the ruling, but we're not sure what aspect of the ruling, and you're arguing about something that's beyond the scope of what was in that ruling? Is that what I guess I'm not following that argument.
No, Your Honor. With all due respect, what I'm saying is the statute has a reason why you have to file in the manner. And I agree with co-counsel that if he had called it a verified complaint, but in fact it had everything that a notice of appeal has to have, the court would have jurisdiction, and frankly, I wouldn't have filed the motion to dismiss. But you need a statement of the issues that are presented for review. We did not have that. We need to understand on what basis are you alleging that the decision below was incorrect. We didn't have any of that. We had a general statement. We don't like what the hearing officer said.
I'm looking at count 2. They've denied their constitutional right to procedural due process. So they didn't like the procedures during the, and then in paragraph 64, the finding and ruling was not supported by fact or law.
How? Which ruling? Which part of the ruling? That's, if we can go back to the beginning, we know that the general rule is you can't sue the government. You can only sue the government if, when, and how the government tells you you can sue it. And 904 strict tells us if you want to sue the government on an administrative appeal, this is when you do it, and this is how you do it. They didn't do it, and respectfully, This is very different from a...
Counsel, your time has run, and
Oh.
I've given you a little bit of leeway, but if you'll finish your
I will. While we're not totally familiar with the case, Your Honors cited, but the rule that a corporation must be represented by an attorney is not a specific rule of JRAD. That is a general rule applicable to the courts. So I believe there's a huge difference between the court excusing that failure and this court saying in the manner doesn't mean in the manner.
Thank you, counsel. When you're ready.
I have three things I have to address. I hope I have enough time. I heard that 12902B only applies to appealing to the administrative agencies, but then I hear that 12902B, you have to do it by the manner prescribed. Well, it doesn't just apply to appealing to a different administrative agency. Obviously, it says you have to appeal it by following the terms. So we kind of went over that. And the other, you were asking questions about were the parties confused. And I can represent to this court Mr. Peck was the lawyer at the enforcement action. Mr. Peck was the lawyer at the Board of Adjustments. Mr. Peck was the lawyer at the Superior Court action, and Mr. Peck's the lawyer here. So there's no way in the world that Mr. Peck's confused about what we're doing. There's another, they mentioned the Southwest paint case. Well, that matter dealt with exhaustive administrative remedies, and we clearly did that by appealing to the Board of Adjustments and then filing the complaint here. And really, it's when you look at a statutory construction, 12092B, it says in the manner, but then it goes on. You have to read the entire paragraph or it'd be superfluous. And so it clearly states that you have to file something in the form of an objection, and that's what we did. There were different procedures that had happened procedurally. That's why we were going to leave to file an amended complaint to comply with those procedures. And so the court, it is, and this wasn't a discretionary special action, as you've been hearing all day, this is a statutory right of appeal. So there's two different types of special actions, discretionary and statutory. So either way, this court has jurisdiction over this case per statute, and that's exactly what the case law requires. And I'm out of time, but I want to thank you for your time today, and if you have any more questions, I'm available, but...
All right. I would like to thank you for your arguments today. Very interesting issues. We will take this matter under advisement and issue a written ruling in due course. We are adjourned.
Thank you.
Thank you, Ernest.